You're Mr. Camacho? Okay. Did you file a brief, sir? Okay. All right. You understand that in this court, you're more than welcome to sit there and you can listen, but we cannot permit you to argue because you have not filed a brief. You haven't, do you have an attorney or, all right, you haven't filed anything in this court, right? Okay, all right, thank you. You may proceed.
Good afternoon, Your Honors. Christina Zetterston of Williamson and Rutherford County Bars. I'm kind of all over the place. I'm here, Your Honor, on this case. Obviously, it's a post-divorce case. However, the only thing that we're arguing about specifically is the parenting plan. The parties did stipulate to all other issues in the case. So the only issue is the entry of the parenting plan. This particular case involves two minor children who are, at the time of the trial, I believe were 9 and 13, or 10 and 14. I'm not 100% sure on that, Your Honor. But the younger child did, or the older child did testify twice. He testified at the Pen and Light hearing a year prior to the trial, and he testified again at the trial. Now, the issue in this case is we have a mother who, throughout the marriage, was primarily a stay-at-home parent, occasionally worked outside the home part-time. At times, she did homeschool these children. And then we have a father who did work full-time, supporting the family, but was also an alcoholic throughout the marriage. He, through his own testimony, stated that he spent, up until the time of when the parties separated, pretty much his children's entire life in seclusion. He would be in his room drinking, or he'd be at work. And when the parties separated, the father did go to rehab. And as far as I know, still sober to this day, which is excellent. And obviously, that's what's needed to be done in this case. However, it does not eliminate the past. Now, when the court held a Pen and Light hearing, they found, obviously, that the mother had been the primary parent for these children. The children had been with her since the parties separated when father went to rehab. And he ordered that the children would remain with mother, and she was living out in Hardin County in Middleton, which is where the parties originally were from. They had lived there for years prior to moving to Murray County, where they'd only lived for 2 to 3 years prior to the divorce. Now, at that Pen and Light hearing, the court found father was not credible. He was evasive. Clearly, he had had an alcohol problem. And he was in recovery at that time for just a couple of months. And the main and basically the only finding the court found at that hearing against mother was a witness who was called by the father, Mr. Adam Stamey, who had been a friend of the parties. He was, I guess at the time, casually seeing mother. Potentially, I think it was kind of back and forth. I think it was agreed, and mother may have admitted at trial that she definitely downplayed her relationship with him. But the court found he was a horrible witness. Mother admitted he was a horrible witness. Anyone was there, he was a horrible witness. Obnoxious on the stand. But that was the only finding about Mr. Stamey. The court additionally said that mother would be served well not to expose the children to Mr. Stamey. But there were no findings entered about Mr. Stamey, nothing why they wouldn't want the children around Mr. Stamey. None of that was entered in this court in that order. Then fast forward a year later, we have a final trial. And at that trial, we hear testimony from obviously the parties. We hear from the father's sister, as well as we hear from the older minor child. This older minor child declined to make a preference as to what parent he wanted to live with, but did state that he liked the plan as it was. It was the new normal. He was used to it, and he was comfortable. He also stated that he occasionally saw Mr. Stamey, mainly because Mr. Stamey's daughter was best friends with his little sister, the party's younger minor child. So Mr. Stamey would come by, drop his daughter off, they'd play. Now, what also, I'm sure y'all know from reading the record in my brief, Mr. Stamey and mother, Mrs. Camacho, did end up getting together and dating, and had a child. There was a new baby born, and it was testified by the older child, it was Matthew Jr., that he did see Mr. Stamey a little bit more often as he'd come to pick up the baby. But he wasn't living there. He didn't see him very often at all. Now, it's fair to say that the parties were still married. Mother was technically in an adulterous relationship with Mr. Stamey. That she admitted to inappropriate marital conduct because of that, even though the parties separated because of father's alcohol abuse. This relationship occurred after the separation, but as everybody knows, you're still married. You don't get to go do whatever you want. So she stipulated to the grounds for divorce, and then we moved on to a parenting plan. The problem being that in making findings about the parenting plan, the trial court judge used Mr. Stamey and the mother's relationship with Mr. Stamey essentially as a reason to find nearly every factor in father's favor. Now, as you all know, a mother or a father is not to be punished because of an extramarital affair by awarding custody of the party's children to the other party. This has been found by this court, Sutherland versus Sutherland in 1991, Long v. Long in 1972, and it's just completely inappropriate. And the court has also said infidelity or indiscretion does not ipso facto disqualify a parent from being awarded custody, but when such activities involve neglect of the minor child, such neglect may be considered in a relationship to the best interest of the minor child. That was also found in Sutherland, citing Mims v. Mims from 1989. Now, there was no evidence.
Let me ask you a question. So, if a trial court uses the aspects of the relationship and finding those relevant to the best interest factors that the court has to look at, are you saying that that's improper for the court to even mention those things in consideration of the best interest factors if the court feels that it impacts those?
I do not think that it's improper in and of itself. I think that in this particular case, the way that the trial court did so was not proper. And specifically, I'll go into why that is. Looking at factor number 2, this is the parent's past and potential for future performance of parenting responsibilities, willingness to facilitate and encourage open relationship. They can look at the likelihood of honoring a parenting, previously ordered parenting plan, etc. And the trial court found that this factor had favored mother previously at the temporary parenting hearing. He also found that the parents continued to work together. They facilitated a nurturing, loving relationship between the children and other parent. There have been no violations of the court's order. He then continued to consider her continued relationship with Mr. Stamey to be a violation of the court's order, despite the fact that there was no order regarding her relationship with Mr. Stamey, and the fact that there was testimony from the minor child stating that he only saw Mr. Stamey when he would come to either drop off his daughter to play with the little sister or to pick up the new baby. It was the only time he saw Mr. Stamey. And so using that in this particular factor was inappropriate because it doesn't relate to the factor. He first made findings as to everything in that factor and then added some to it that had nothing to do with the factor. And then the court additionally made a statement saying the court further found Mr. Stamey to be completely without credibility, his testimony incredible and not worthy of belief. However, if you look back to the Penalty order, the court made no such finding. The court made a finding that Mr. Stamey was a horrible witness. That is the only finding that the court made about Mr. Stamey. So
Are you saying the court can't look back at prior hearings and make those type determinations?
I'm saying that the court is not permitted to base findings solely on its memory, and there are specific cases which says that. And in particular, it says that when the court can take judicial notice under Rule of Evidence 201 that a witness testified to particular facts, but it would move out of the realm of judicial notice and into the realm of being a witness if the court relied upon the credibility of that witness based upon its memory of the testimony. So this is solely based on the court's memory. There was no transcript. This is the order. In addition, as I'll point out soon, again, there's another point where he relied on his memory wrong. He was completely wrong when he relied on his memory. So
So you're saying the court cannot rely upon what it heard, what it believes it heard previously, and apply it in the hearing before it?
not according to State versus Jackie Crow from this court in 1997, which, in addition, Hughes v. State from this court in 1969, which said that in that case here, the trial court relies on its own memory rather than taking judicial notice of its own records or the record in the matter, which is not the same.
And the record, I'm assuming, has to be either a transcript or an order. Is that correct?
Right. From my research and all of these readings, I think the issue being, of course, that we're talking about, especially in this particular case, a hearing that was more than a year prior. And so nobody's memory is perfect. And obviously he remembered, and there was an order that Mr. Stamey was a horrible witness. He was a horrible witness. But there was no finding about his credibility, no mention of his credibility, because he didn't make a finding that he was not credible. To then a year later say, I found him not credible last year, is just inappropriate. How could he possibly have that level of memory to say, I find him credible? When in fact, he did find the father not credible, which then now he says, oh, the father's credible now. He completely changed his tune on the father now that Mr. Stamey is still around. Now, we move on again to say that factor number 8, the moral, physical, and mental, emotional fitness of each parent as it relates to their ability to parent the child. The trial court again determined that factor favored father due to mother's continuing relationship with Mr. Stamey. However, there was no evidence presented to suggest that mother's alleged moral shortcomings related in any way to her ability to parent the children. And the evidence preponderates in mother's favor. Father had a history of alcoholism. Father had diagnoses for multiple mental illnesses, which he had just begun to treat since this divorce had been pending. Mother, on the other hand...
Is there a transcript of this hearing?
I'm sorry?
Of the divorce hearing?
Can you repeat the question? I didn't hear the start of that.
Okay.
To begin to
There's
treat
no
at that point?
transcript.
Yes, there's a transcript of the divorce hearing,
No,
yes.
there's no transcript of the prior hearing,
No.
of the temporary hearing.
No transcript of that
Is there
hearing.
a transcript of the hearing that you're appealing from?
Right, yes.
Okay.
Yes, there is a transcript of the full divorce hearing.
Did the court make findings during that hearing, or are all the findings contained in the court's order?
During the hearing. And I do, in my brief, cite to some of written findings that didn't make, oral findings that did not make it into the written opinion.
Okay. There were oral findings in addition to the written findings?
Right, he ruled from the bench, and then Mr. Camacho's counsel created the order from that ruling.
Were the oral findings consistent with the written findings?
Yes. They're just larger. I would say, I guess he just had a lot more words to say that got all the way into the ruling, the written ruling. But it doesn't, the whole, I guess the idea is all definitely on paper in the written ruling, but there's a few things that he said. And one thing that I did note were some findings that he had made. So I had said that it wasn't contained in the written ruling, but the trial court, but he did make statements in his oral ruling that Mr. Stamey had been allegedly convicted of simple assault, and that per his memory, he had an aggravated assault charge that had been either reduced or dismissed, but he couldn't seem to remember in his oral ruling. And so that was one reason that I wanted to point out that that's part of the reason why we don't allow judges to simply go by their memory, because he couldn't even remember. And in fact, there was no testimony whatsoever at this divorce trial regarding anything about Mr. Stamey. And in fact, Mr. Camacho testified that Mr. Stamey was a good friend of theirs for some 20 plus years. He had lived with the parties for a time. He had been around the children regularly. And the only thing that Mr. Camacho raised when testifying was that he didn't believe it was good for him to be around the children while she was married. And that was it. That was the only thing that father raised about Mr. Stamey. And then Your Honor, I think that Your Honors, it's important to note also that the trial court included a paramour provision in the parenting plan. There was no testimony, zero testimony about a paramour clause at the trial. It simply was in the father's proposed parenting plan, which the court then adopted. And this court has found that paramour provisions that do not show that it would be in the best interest of the children specifically, or that doesn't show that the presence would pose a risk of harm or detriment to the child, this court has removed those provisions. Mashburn v. Mashburn being the most recent opinion that has done that I'm aware of. There's no best interest finding related to the paramour provision. In fact, actually, the court didn't mention the paramour provision in its ruling. It simply adopted it because it was in father's proposed parenting plan.
So the father put it in his parenting plan. The trial court had never discussed it.
Right.
Never expressed concerns about it.
Right. It was never, I mean, the only thing the trial court really said, I mean, the trial court even said, and I don't think this made it into the written opinion either, but said in its oral opinion that it would be pointless at this point to order for Mr. Stamey not to be around the children because they have a child together. He's going to end up around the children at some point in time.
So
and he even said that.
It would be difficult for you to explain what under inappropriate circumstances meant in the paramour plan, I assume, or the paramour provision.
It's very vague, in my opinion. What does under inappropriate circumstances mean? In general, you would assume it means people that aren't married sleeping in bed together. That would be my assumption is what that's supposed to mean. But there is no statement about it whatsoever. The father never asked that Mr. Stamey not be allowed to be around the children, and he even stated, after being explicitly asked, do you have any other issues with Mr. Stamey? His only issue was mother having him around the children, essentially as a boyfriend, while she was still married. That was it.
All right, thank you.
Thank you, Your Honors. Happy to be back in person.
Mr. Camacho, since you have not filed a brief, again, we can't let you argue, but you've heard this. You'll receive a copy of whatever the trial court, or excuse me, whatever the appellate court does. What we'll do is we're going to take this matter under advisement. We'll review the record, and hopefully in a short period of time, we'll file an opinion, and you'll receive a copy of it. Okay? All right. Thank you, sir. This court will stand in recess to the call of the next docket.
All rise. This Honorable Court of Appeals stands adjourned.